I'm Drew Stevenson. This is for my administrative law class. Here I'm going to be talking about the Association of Administrative Law Judges v. Colvin, a 2015 case from the Seventh Circuit Court of Appeals. This case is about administrative agencies, in this case the Social Security Administration, trying to manage or maybe control their adjudicatory personnel, and in other words, their administrative law judges. This is in tension with the idea of judicial independence that the APA sets forth for administrative law judges. So we'll see how this works out in this case. Let's dive in. Let's meet the parties in this case. The Association of Administrative Law Judges is kind of like a union of ALJs, a lot of them for the Social Security Administration, which has more administrative law judges than any other federal agency. In fact, they have as many as most other federal agencies combined, and they handle a huge docket of cases every year, which is part of the plot of this case. And also there were some individual administrative law judges who joined as plaintiffs. Our defendant is Carolyn W. Colvin, who just happened to be the acting director of the Social Security Administration at the time the complaint was filed. She wasn't directly involved in the events that gave rise to this litigation, as far as I know, or as far as the case indicates, but because of some of our statutes about how these cases are brought against agencies, the head of the agency is listed in the caption of the case. So what was our big issue in this Colvin case? Well, the question is whether the Social Security Administration was interfering with the decisional independence of the administrative law judges by requiring that each of them decide at least 500 disability cases per year. At the time that this kind of rule came out and this case was brought, a little more than half, 56% of the administrative law judges for SSA were deciding fewer than 500. They might have been close, but they were deciding fewer than 500. In other words, this is a productivity quota or a production quota. It also gives you a little glimpse into the volume of the cases. Every single judge is supposed to decide, and that usually involves having hearings for and write opinions for 500 cases every year.
Well, it just means I'll have to work faster.
So what do we mean by a quota, and did it really interfere? We start in 2007 when there was a directive issued from Social Security Administration's chief ALJ to all of the other ALJs that purported to set a goal for all the ALJs to, quote, manage their docket in such a way that they would be able to issue between 500 and 700 legally sufficient decisions each year. So why did they do this? Well, the Social Security Administration was trying to reduce this huge backlog of disability cases that they had. And the administrative law judges claimed that the administration called this a goal, but they ended up enforcing it with both formal and informal disciplinary measures that basically made it an enforceable quote and an enforced quota. They said that this violates the Administrative Procedure Act because it interferes with their judicial independence.
This office has an enormous backlog of cases.
I have a crazy backlog of cases.
Boy, I got a backlog of cases built up from here to Sunday.
So let's talk about the statutes in this case. We have 5 U.S.C. sections 554D2, that's part of the APA, and 3105, and both basically say that the administrative law judges should not be subject to direction or supervision by any other agency employees and cannot be assigned inconsistent duties with their role as adjudicators. The ALJs in this case claimed that the quota for caseloads constituted a forbidden direction or an inconsistent duty, and that interfered with their independent decision-making. Except that we end up with a couple of statutes in tension in this case, and it becomes a conundrum how to reconcile them. The district court in this case had dismissed the complaint because they said they lacked subject matter jurisdiction. And the reason they said they lacked subject matter jurisdiction is they thought that this complaint was preempted by the Civil Service Reform Act, or CSRA. The CSRA defines personnel practices to include, quote, significant changes in duties, responsibilities, or working conditions. So we'll see how this plays out. Even though this quota was a significant change, the Civil Service Reform Act does not actually prohibit a production quota increase unless that increase violates a statutory list, one of the items on a list in the statute, and this challenged quota did not. On the other hand, the Civil Service Reform Act, if it applies, provides the exclusive remedy in such cases. But because this case doesn't qualify under the list of possible quotas that are forbidden, then there's no remedy because this would be the exclusive remedy. So the case goes to the Seventh Circuit Court of Appeals and ends up with Judge Posner on the panel. Richard Posner is one of my favorite jurists from the last 100 years. I really like his writing style. I recommend both his cases and his books. He was a prolific author. So they affirm the lower court's dismissal, but have a slightly different take on the reason why. And the appellate court here focused on the nature of the alleged interference. And part of the discussion in this case is about the intent of the administrators, the Social Security Administration, versus the actual effect. The administrative law judges here argued that the quota pressured them to award more benefits because they said that writing denials takes longer since a person can appeal their denial. You end up writing a longer opinion to justify your decision. And therefore, they said that that would alter their decision making, that there was sort of a subtle pressure to be more generous in granting benefits instead of just doing what they thought was the right thing on the merits of the case. This argument created a lot of problems for the appeal. The appellate court found that it would only be persuasive if the Social Security Administration had imposed a quota because it actually wanted higher award rates. But it was pretty obvious to everyone that the Social Security Administration's aim or goal was just to speed up the decision making to reduce the huge backlog in cases. And any increase in the award rates in these cases would be unintended and presumably an unwanted byproduct. There's a long history of the Social Security Administration accusing the ALJs of actually being too generous. So there was no real reason to think that they were trying to influence the direction of the decision, how the cases would be decided, then they were using the quota as a means to an end. The means to an end was to have the quota to clear the docket faster.
We got a backlog 6 months deep and you want us to move slower?
I pulled out a quote I like here from the opinion. It said that an incidental and unintentional effect of a change in working conditions is not actionable under the Administrative Procedure Act. In other words, it may have an effect on them, but that wasn't really the goal. This wasn't a means to an end the way the ALJ said. They were just trying to reduce the backlog. Now, the Seventh Circuit acknowledges that the decisions might not be as good. There might be a decline in the quality of the writing. They might be hastily written and less well reasoned. And that might have another indirect effect of more of the cases ending up getting appealed into federal district court. But all of these are just consequences of the huge docket and the time pressure they're under. They're under, not interference with how the ALJs should decide individual cases. This case really highlights an ongoing tension between the need for administrative efficiency. Everybody wants government bureaucracies and agencies to be more efficient. And in this case, that was reducing the backlog via a production quota versus the administrative law judge's need for decisional independence. So even though the APA may have some sort of remedy for an agency that interferes with the decisional independence of its adjudicators, that doesn't extend to sort of incidental or secondary consequences of a bona fide production quota. So if you expect the ALJs to do their work and close their cases and stay on task, that's okay. Now, the court did acknowledge that in theory, there could be an extreme quota that would violate due process, like having a rule that they could only take 15 minutes per hearing, right? Disability cases are pretty complex. There's a lot of medical records to sort through, usually oral testimony at these hearings from the claimant. And so that would be unreasonable. But that's not what was going on here. They weren't setting a rule about how long the hearings could last, just how many opinions or cases needed to be decided and opinions written each year. We have a concurrence in this case from Judge Ripple. He agreed with the outcome. He thought the case should be dismissed, but he was concerned about the majority's reasoning in this case. He thought that the majority had focused too much on incidental effects and the agency's intentions. And he was worried that this would set a bad precedent and force courts in the future to inquire into the subjective intent of agency officials, what their real agendas were, and so forth, and that this was inconsistent with Congress's sort of stated intent with the Civil Service Reform Act to limit judicial meddling in agency management. In other words, he thought that we should lean into the CSRA's preemption and dismiss the case more readily. Something that may be interesting for my students in this concurrence is that Judge Ripple actually emphasized that the lack of a judicial remedy here under the APA or the Civil Service Reform Act does not mean that a constitutional violation is not occurring. He suggested that Congress may have intended to leave oversight of systemic issues to itself, or maybe to allow a litigant to raise a difficult due process claim, although he admits that that's going to be an uphill battle. Where does this leave us? Well, there's a lot of questions left unanswered here. This case raises some really difficult questions about where grievances related to administrative judging conditions can be heard and the limits of judicial review over agency management actions. And the opinion really leaves those questions mostly unanswered. Well, it's time to wrap this up. That brings us to the end of our lecture about the Association of Administrative Law Judges v. Colvin, which is about productivity quotas by the Social Security Administration for its ALJs.